Welcome everyone, and thank you for taking the time to join us for our panel discussion, Litigating in a Pandemic, How Remote Depositions Have Changed My Practice. My name is Jeff Cohen, and I am the Director of Business Development for U.S. Legal Support. I'm going to be your moderator today. Joining me, we have a great group of litigators from around the country. We have Barack Cohen, a partner with Perkins Coie, Karen Lisko, a senior litigation consultant with Perkins Coie, Matthew Keenan, a partner with Shook, Hardy & Bacon, and John Strongman, a partner with Shook, Hardy & Bacon. During this presentation, feel free to submit any questions you may have through the chat function on the platform, and we will do our best to address them at the end of the presentation. That being said, let's go ahead and get started here with our first topic, and that is going to be preparing for a remote deposition. Karen, I'm going to direct this first question to you. With the majority of depositions still taking place remotely, how has your firm adjusted their approach in terms of preparation?
Well, we know that a lot of it starts with having the right equipment, and even that has evolved. But we have what we prepare witness kit just in case a certain deponent is lacking something to make themselves seem as professional as possible when they are deposed. So the first element is something that makes sure that you've got some kind of a quality mic. Sometimes that's part of second element, which is a wired set of earbuds. It is possible to try to risk the Bluetooth earbuds, but sometimes they don't work. So it's important to make sure that you're wired, just like a computer should be connected to the Ethernet as well. So it's an analogous scenario for that. So if you put up the second and the third components, on the next one, then the other part is in-person lighting. This is one of the things that we find to be the most deficient. People just don't have the habit of thinking about lighting their own faces. Yet if people appear too shadowed, or if they have a camera that's in front of them, but a window behind them, they don't appear as alert, as bright, as literally engaged as they should when they're in the deposition chair. Another piece that we also include that we often send out is a background. We're all used to seeing virtual backgrounds these days, and unfortunately, people can fade into the background if they move their head or their hands around. So that real background tends to be better, although there are some scenarios now where people are using green screen backgrounds with a virtual background added to it. And then another piece that we include when we send this off is there certainly are most witnesses who have a laptop available to them. But if you add the next element, we often find that witnesses need either a second laptop or a second monitor to enable them to be able to see on the second screen exhibits that are pulled up, things that they need to refer to without having to squint and share real estate between exhibits and the questioner on just one screen. So if the deponent doesn't have that available, we recommend having that access either through shipping them something or making sure that they avail themselves of it. Then the laptop riser is actually just meant to be something to make eye contact. But this is where things have already evolved, we find. In fact, right this minute, I am using a new kind of camera that rather than having it above my monitor where I forget to look up, it is actually a gooseneck kind of camera that now means I don't have to elevate the laptop anymore, but I can look straight at the screen and the camera is right eye level. But if that's not available to the witness, then a riser is a possibility and something we include.
Now you mentioned a riser. I'm actually using a cardboard box today. It kind of varies between cardboard box and an old photo album. So whatever you have available just to raise the height of your computer is going to work very well. So in the preparation process, what are some of the key points in your preparation for a remote deposition, I guess, outside of the actual casework that takes place?
So Jeff, I'll take this one. So as Karen touched on, what we really want to do versus a traditional in-person deposition is get really competent with technology. That includes not only making sure the lawyers understand the technology, but also that our witnesses understand the technology as well. It just becomes of critical importance in this context.
That's a good point. And sticking with you then, Barack, What have you been doing differently to prepare your clients for their remote depositions as opposed to your process when you're preparing for maybe an in-person deposition?
So in broad outlines, the process is still the same. You still want to focus on the substance, the substance of what the deposition will cover or the testimony will cover. But the real tweak is making sure the technology is baked into the preparation at all levels. So that means making sure you're comfortable with it, thinking about how it affects the process and the negotiation. I know we'll talk a little bit more about negotiations with opposing counsel, but really thinking at all levels about how the technology might affect what you're doing.
Yeah, really the importance of ensuring that your client has competency with technology can't be understated. And to achieve this, have you and your team conducted training sessions either internally or with the help of a litigation support vendor on their remote deposition platforms?
We have. What I have done is I've had the vendors create a sandbox for us to play in. We'll go in as attorneys and we'll get comfortable with the technology, and then separately we'll bring in the witness as well to play in our sandbox too. And then we all, just to continue the analogy, we all play together, going through mock questions.
Makes sense. And then John, I know you've also done a lot of prep work in the past. How about yourself?
Yeah, and I think one thing that I would add to what Brock said, which I think the sandbox analogy of the description is very apt, is that, if you were to litigate a matter outside of the virtual context, you would want to do mock deposition practice with your witness, and this is no exception. So in my mind, the mock deposition has really two components now. One is practicing questions and answers with the technology. So in the sandbox, you're actually practicing, and then adding on the layer that we always have had before, which is, you're simply working through the give and take substantively, just like you would normally. But you have to add on that component of practicing and doing some mock exercises with the technology too. So, in my experience has been that the vendors that we've worked with are more than happy to set that up and to help you do it. So it's been very valuable.
So then, John, kind of building on that thought, when you're preparing for your remote depositions, obviously the technology is an important piece, but what about the specific hardware or maybe software that you'd recommend to anyone taking a remote deposition, whether it's, your co-counsel or your client?
Well, I know that, resources aren't unlimited. I understand that. That being said, if there's any opportunity to have more than one monitor available to both yourself and then obviously to your witness, it makes a huge difference. Because I know it's important, especially as a witness and or a lawyer asking the questions, being able to look at and engage, even though it's virtual, the person that you're having a conversation with or having this deposition experience with, or even a court in a hearing, which happens. With another monitor, you can have up, whether it be an exhibit, whether it be notes, you can have access to the content that you're needing to discuss, but also still engage in that back and forth kind of visually with the witness or the audience. So that's really important. So that's my main thing, is having more than one monitor at your disposal, if at all possible.
And then Karen, I know also as we've talked about your kits, you've talked a lot about not only the equipment, but some of the scenarios that your witness might find themselves in. Can you talk a little bit about that?
Yes, part of what we want to help avail the way we're preparing is knowing how he or she is visually coming across. And so with that kit in mind, or even if they have all the resources already, some of these visuals that we're showing you right now will show some of the more common mistakes we see witnesses make. This kind of busyness or the lighting behind the person's head, casting her face in shadow, those are both extremes you want the witness to avoid. So even if there isn't some kind of an actual background shipped to the witness, all she's done here is simply close the curtains, and she has room darkening drapes. That's a crimson color. Having a little bit of color is good, but it should just be neutral. Because at the end of the day, you want the deponent to be the main visual. And sometimes those distracting backgrounds create total opportunity for the viewer to be looking around the witness, or worse, it makes the witness look disorganized, and nobody wants that, at least who's defending the deposition. Another thing to keep in mind is even just literally the lighting. One way to cheat on this, if someone doesn't have all the technical tools and tricks, is frankly to just think about looking at the camera as noon and then looking at, if you figure a clock, 10 a.m. and 2 p.m. for the better view, where she just had lamps on her desk, but the lighting was lighting her face. It wasn't behind her, it was in front of her. Then another key to consider is also looking at camera angle. It's very common still, if you think about a lot of the video conferences we are all part of every single day, that you can tell someone who hasn't just really given enough thought in terms of, is the camera way above them, is the camera way below them? And we all tend to want to look at the screen. So that's again why I say there's an extreme of it being she's it. Obviously that's an extreme example, but that to make sure that the camera is eye level. So when you compare it to that straight on view, all she's done is make whatever adjustment she needed to make that happen. And again, as I said before, if you've got the luxury of the camera where it can be in front of the monitor, that makes it even better because the deponent can be looking at the questioner and at the camera in one fell swoop.
That's a great point.
And another, yeah, I think we might have one more. Yes, so this is the, again, the extremes, video attire. We know it's not professional way to be so busy, but the key is, what do you do? Well, part of it now is even being used to in a typical conference room to wear the extremes of black and white. You want the deponent to avoid both those extremes if you're preparing her or him. So the better attire would be cooler colors. She's wearing light blue here. Same applies for male deponents. A light blue shirt is better than a white shirt because the stark contrast isn't as effective when it's somebody appearing through a video deposition. Thing to avoid in terms of a really busy tie or certain broad colors are the kind that will actually create waves on the screen. So again, the cooler colors, the blues, the grays, the browns, something that is typically solid color is a better way to go, but also something obviously that the witness feels comfortable wearing and that reflects the role witness play in the deposition.
Now, you mentioned the position of the camera, and just also from a personal standpoint, of course, if you're going to be sitting in front of your computer for a deposition for 6, 7, 8 hours, whatever it may be during your day, you don't want to be sitting in a position of discomfort. You don't want your client to be sitting in a position of discomfort. That can also impact the flow of your deposition. Matt, we haven't had a chance to hear from you yet, so I wanted to ask you a question. Where have you physically been for your depositions? Have you been going into the office and participating through your computer there, or are you dedicating a space at home?
I've been coming in the office. I mean, our office, I think, technically is closed, but we have a support staff here. I mean, I in my mind, you know, eliminating the things you can't control, and in the case of this presentation, technology and the difficulties and uncertainties of technologies. When I come to the office, I have the IT staff here. I also have a Cat5 broadband that I'm using and not Wi-Fi. And it just gives me a little bit of emotional confidence that at least the most basic things will be addressed. All of the software platforms, Zoom and WebEx, have had a number of upgrades in the last couple months for security reasons. And so you are finding glitches with those applications, and you certainly don't want those to develop in the day of the deposition. I mean, even today, even an hour ago, I had a problem booting up because of another software application that had just been updated. I think the bigger challenge is going to be, obviously, the witnesses that I have responsibility for. I'm going to make certain that they're going to be in a location that's going to answer all the check the boxes. But the more difficult issues are going to be the plaintiffs, for example, who are deposed by Zoom, where they are. We have a lot of anecdotal experience with plaintiffs being deposed at their home, for example. And we'll talk about this a little bit later. I mean, stipulations normally should address where the witness is going to be and make certain that the witness has adequate safeguards in terms of technology, but that hasn't always happened. In this day and age of mass tort, you have plaintiffs' attorneys who will sign up a client geographically far separated from where they might to be. Recent deposition I had, the plaintiff's attorney was from Utah. He appeared remotely. The witness was in Mississippi. The attorney there didn't have the luxury of having an office where the local client could go. So I think location continues to be a little bit of a challenge depending on the witnesses. Obviously, if it's an expert, they're going to have a secure location. But if you have a fact witness, if you have a plaintiff, some of those challenges are still being worked out.
That's interesting. John, I know you've also had a lot of experience in both locations. If you want to talk a little bit about that as well.
Sure. I would add that, I've taken depositions from both the office and my house. And, Matt is right that you have the background support in the office that you may not have at home. That being said, it can be done. If it needs to be done, it can be done at your house. And, what I have found is that from everybody involved, the other lawyers for the most part, the witnesses, the vendors for the court reporting services and everything else will give you some amount of grace too as you're navigating it from home. So don't think it can't be done. If you feel like you need to be at home, it can be done. So.
And speaking from the vendor perspective, we get the question a lot, can we come into your offices? Now, depending on your local guidelines for COVID restrictions, some offices are allowed to be open, some are closing. I know a lot of vendors and firms alike have installed plexiglass dividers in their conference rooms. So there are measures being taken for the assistance in in-person depositions in terms of a hybrid approach where some people are in person, some people are remote. The key is really just talk to your vendor, see what's available, see what you're able to do. Going back to you here, Barak, what do you do during your depositions for communication's sake? So internally with your team and also with co-counsel as you're preparing for these depositions, you don't have them in the room with you, assuming everyone is remote. What has been your strategy preparing for that circumstance?
Well, going back again to the notion of preparation and technology, we try to anticipate as many problems as possible and practice through them so that if you have a problem or an issue that comes up during the deposition itself, we already have a way of responding to it. So we don't need to communicate actively during the deposition. Tends to let me take a backseat approach because the witness is already ready for what's about to happen. When things do pop up that we haven't prepared for and communications are necessary, depending on how you're doing things, you can take different approaches. For many of the situations where I've had to represent somebody in testimony or in a deposition, my witness will be in a completely different part of the country. So one approach we've taken is to mute the system and have calls separately outside of earshot or in a separate room so that we can trade information. If the witness is co-located with you, which is the best way to do it, then you move away from whatever system you're using and meet in another room with masks on and appropriate social distancing or whatever you've agreed on with the witness and confer that way. So that's typically how I've approached it.
And I know, Matt, you had mentioned in your earlier commentary some of the stipulations you can put in place. If you wanted to talk a little bit more about that.
Yeah, I'll take just a few minutes on this because I think it's worthy of a more robust discussion. And I think it's really incredible the evolution of jurisprudence in the last 6 months in this area. It was just 6 months ago, you had federal courts ruling like this court did in New Mexico in the case of Quarry versus Wells, where the court really in just a 2-page opinion said that the court is doubtful that these critical depositions which are central to this case can be effectively and efficiently taken by video conference in light of the probable length of the depositions and the need for exhibits. And the court, and this is not a particularly complicated case, the court went on to say that plaintiff neither disputes nor indeed addresses the point that This potential prejudice to defendants is noteworthy, and the court in its discretion will deny the plaintiff's motion to conduct remote deposition. So that was in April 10th of 2020. In a period of about 3 months, then you had the case, which I think is the bellwether case that most courts are citing to allow and in some case actively push remote depositions, and that's the In Roy broiler chicken antitrust litigation. And this was a massive case in which the plaintiffs were pushing to take the depositions of numerous employees at the poultry producers. And this was in the midst of the pandemic, in which the attorneys for the defendants noted that the poultry producers have been working with the federal, state, and local authorities to comply with applicable safety standards, including substantial modifications with facilities, and to make certain that the food supply chain remains intact. So it'd be hard to imagine witnesses that would have enough balls in the air at this time in the summer, yet the court without hesitation ordered all of these depositions, including the preparation of these witnesses and the handling of literally thousands of documents, to be taken remotely. And so the broiler chicken litigation really, I think, is the bellwether where the pendulum has swung to the other extreme. And I think all this litigation has really emphasized the importance of stipulations. And today, here in December, there's a huge body of jurisprudence that is out there about what are the appropriate stipulations that have to be in place. Early on, in the early part of the summer, these were largely negotiated by counsel. But today, courts readily adopt their own stipulations. And just very briefly, these run the gamut from if the parties agree that the depositions can be used at trial, that there are rules and stipulations about what can happen over the breaks. There's stipulations about what documents the witness can and cannot refer to during the deposition. There are stipulations about the amount of contact that can go on, and typically there's no contact allowed between the counsel and the witness during when they're on the record. Indeed, there's some plaintiff bar journals who have argued that there should be no contact between the witness and his or her attorney during breaks. I haven't seen any stipulations to that so far, but I have seen in the plaintiff's bar journals advocating that plaintiffs should push for that. You have a lot of stipulations about the exhibits, how they should be handled. Early on in this litigation, the protocol was exhibits were sent in advance to the witness, so he had a hard copy, and there were rules about when the witness could open the box and review the exhibits in advance of the deposition. I think today, with the help of vendors like this one, a lot of the exhibits now are being handled online and without the need for hard copies. But again, if you're talking about a treating doctor or someone like that, they're going to have their own chart there, and they're going to want the hard copies. Among other stipulations, and I belabored this perhaps a bit too long, but the names of the lawyers who are going to participate, whether or not all the attorneys participating need to be shown on the video and have a video record, which I would strongly urge defense counsel to insist on, so that the plaintiff's attorney is on camera, and I think that also might tamp down his conduct just a bit. So, you know, under the heading of stipulations, I mean, the document I'm looking at has almost 23 separate stipulations, and these are now widely available. A lot of the professional organizations like PLI and the ABA have these. So we've come a long way on the stipulation front than it was in June or July, where it's kind of the wild, wild west. And I think the net effect of this has been kind of leveling the playing field between plaintiff and defendant, and in fact witnesses too. So a lot of information is out there today.
I think a key takeaway is really stay up to date with what's happening with the courts. As we all know, it's an ever-changing environment, and it can impact your case without you even being aware of it if you're not being abreast to all the changes taking place. It's really a good segue to start talking about our next topic, is really during the deposition. So we've discussed a lot of the preparation process for depositions, but I want to talk a bit about what happens when we actually get into the remote deposition itself. So let's go back to you, John. What are some of the steps that you've established, if any, really, to eliminate potential interference with testimony by witnesses' counsel?
Really this, actually goes back to what Matt was talking about. And frankly, I guess it's the lawyerly thing to say, but preparation. So we're in a situation now where these depositions are not isolated one-time events for the most part. So you're working up a case, or you're working within the framework of a litigation where, to be honest, both sides are going to have to take depositions. And so there is a need and really a incentive, I guess, for both sides to cooperate on how this is going to go. And so working through, just like Matt said, some of the things that both sides know they need to get worked through ahead of the deposition has really been helpful in terms of preventing interference or even confusion on how these things are going to play out. So that's been my experience, is if you just are willing, most of the time, the folks on the other sides of our cases are at least willing to work with us to find reasonable ways to navigate circumstances, particularly when both sides are going to be on taking depositions, defending depositions. So doing that prep work has really made the difference in terms of trying to keep the interference down. Obviously, in the heat of the moment, just like any deposition, you're going to have issues. But I think with that little bit of prep work, you can certainly keep them to what's I guess normal, a normal level.
And then Barak, I know you've also in the past spoken a bit about just the actual position of the camera. If you wanted to talk a little bit about that, that'd be great.
Sure. So if you are taking a deposition or taking testimony, one concern you might have are things the witness is doing, below their face. So you might want to make sure the camera is positioned in such a way that you can figure out if they're kind of manipulating things, looking at, referring to things you might want to know about if you're questioning them, but making sure that you have a complete view of vision from the waist up.
That's a great point. And, Karen, I feel like I haven't heard from you in a while, so I want to direct this next question back to you. When it comes to exhibits, I know earlier Matt was talking about a lot of different approaches to exhibits. How have you been introducing and sharing exhibits during a remote deposition?
Well, there's a lot of mediums, and I know Matt spoke to the fact that nowadays we're using vendors who will make those available electronically. But the big key is to make sure the witness knows his or her rights in terms of when you share your screen. So one of the things that we've done in certain matters is in advance to think about and to talk with opposing counsel about allowing the witness the right to control the screen. If it's a longer document that the witness should review before providing an answer in the deposition, too many witnesses don't think about whether or not they have the right to review it in its entirety. And if you think about it, this is something we grappled with before the pandemic, when there was a hard copy available. And so the goal is to make sure your witness, if you're the one defending, understands that it is his or her right to become familiar with the entirety of the document. And secondly, to take the time they need to look at it. And it's something as simple, since it's on a screen oftentimes, to make sure the witness can scroll at his or her pace instead of thinking that they've just got to defer and only look at one portion of one exhibit. So we make sure that the witness realizes that is an important option for him or her to exercise.
That's a great point. John, I'll circle to you on that same question.
One thing, if it were up to me, I would avoid even using sharing the screen as a method of sharing exhibits, to be honest. I know it's not always avoidable, but there are a lot of different ways that it can be done, and I've seen it done and done it a whole bunch of different ways during the deposition. So you've got some online platforms where you can have folders set up ahead of time to put your exhibits in, and perhaps you just simply move your exhibit from one folder to another that then allows both the witness and the other side access to that document, so that then the witness or the other lawyer, for that matter, has the discretion to go through it entirely as they see fit. Similarly, I've had experiences, although a little more clunky at times, but people sharing PDF documents through the chat functions on the various platforms that has been done and can work. Emailing an exhibit to all the parties, including the witness, can work. But what you do through those mediums is at least avoid what Karen was talking about and having the witness feel like they don't have control of the document. So that's been my experience, and it can be done a number of ways. But ensuring that your witness does have, or you, if you're defending, really can see and read the whole document is important.
Really the key is there are so many ways to introduce exhibits. I mean, Matt mentioned hard copy. You talk about electronic copies, platforms. The key is understanding, and even a vendor like US Legal Support, we provide different methods of exhibit introduction, some that are geared towards smaller cases with minimal exhibits, some that are geared towards large-scale complex litigations with thousands, if not tens of thousands of exhibits. So developing a plan with your firm, with your office, with your vendor is always going to be important. And once you have a method that works for you, stick with it. If you have the power, if you're leading your deposition, do what is most comfortable for you. That's really going to be something that's kind of the key takeaway from these discussions, is do what works best for you. And on that same thought, if you're doing what works best for you, you can avoid a lot of the confusion and frustrations. But obviously, you're not always going to be in charge. So, Barak, I want to come back to you. Have you experienced any issues during your depositions where counsel becomes frustrated with the technology and maybe becomes then agitated or even aggressive during your depositions?
That can happen, but I think in general, the level of tension and arguments you get in a remote deposition is about the same as I've seen in an in-person deposition. What I have noticed is that the argument tends to be a little more dampened because the media tends to mute emotional expression a little bit. So it's harder to yell and get excited at a video monitor versus being in person in front of somebody who's really, really irritating you. So pretty much the same thing, pretty much the same level of interaction, same type of interaction. Slightly less emotion, which can be a good thing, actually.
That's a good point. Matt, do you want to expand on that a bit?
Yeah, it's real interesting. I think my law partner, who's next door to me, initially he was very opposed to this whole concept of remote depositions because, as he described to me, he felt like he was losing his ability to have influence on the witness and to he was essentially didn't feel like that he was able to be an effective advocate for his witness in these depositions, which is in a very high-profile MDL mass tort. And I think, I've been practicing 35 years. I think we're used to certain procedures and protocols where we go and we sit the night before the deposition and we get a sense for where the witness's anxieties are and then in the deposition sitting to the witness's right or left, we get a real good sense for the momentum and the flow and how the witness feels. And, it's hard. It's hard to get an equivalent sense for that when you're talking about doing it remotely. But here's the interesting thing is the trade-off is what we've heard is the witnesses themselves very much appreciate this technology because it's more a search for the truth. And the gamesmanship and the egos and all the things that we have all seen over the years that plaintiffs' attorneys bring to depositions is gone or is muted or largely scaled back. And so witnesses very much prefer the remote depositions because they feel like they can get to the fact. This is an exercise for the truth, which is what they're there for. So that's been real interesting. And some witnesses have demanded that the depositions be done remotely for that reason.
It's an interesting outcome that probably most people didn't expect when the actual pandemic began. Now, we're talking a little bit about some of the issues that could pop up. What about in any interruptions that take place during your depositions, Karen? Are you able to have any systems in place for dealing with people talking over each other, background noises, a dog barking, doorbell ringing, anything like that?
Well, I would categorize it in intentional interruption and unintended interruption. On the intentional side, we work hard with witnesses to prepare them for that possibility coming to the virtual table from the questioner. And we tend to have some idea most often of who will be doing the questioning and perhaps something about the person's style. So if we know that that questioner tends to be more aggressive, more interruptive, we practice and mock question answer, because again, it comes down to the witness feeling empowered and knowing that one of his or her rights is to give a complete answer. And when a witness gets interrupted mid-answer, we all seen the bad consequence where it sounds like a partial answer is completely different from what the complete answer would have conveyed. So empowering the witness to know that, first of all, that's their right. And then depending on the sophistication level of the witness, this goes beyond whether it's in person or by video, but the sophisticated witness who can say, there are two reasons for that, tends to get interrupted less or tends to get the floor back if they have finished answer part one and part two hasn't come out yet. But then the other part is knowing that if the questioner is successful in interrupting that deponent, that the deponent will get the floor again in the next question. So if the interruption happens and the questioner goes on to the next question, with good grace in delivery, the deponent should be empowered to say, here's the answer to question two, and to complete my prior answer, ABC. That way it happens. Because one thing that's not as easy nowadays is because the deponent is in a different space than the defending attorney, it used to be that a defending attorney might lean in or put up a hand and say, counsel, let the witness finish. Now, the leaning in may not matter as much, but let's say I see Matt next to me right now, and if Matt is defending my deposition, Matt still could put his hand up to indicate that there is interruption happening on the part of the questioner. So it's something at least that I would be able to see as the deponent, and that helps empower me to be able to handle it too.
And then you talk a little bit about unintentional interruptions, and I'm thinking more towards the technical issues that might pop up. And I'd be curious to hear from both Matt and Barak on this. Matt, as you've been in the office, Barak, you've done a lot of remote things. Barak, I'll start with you. How are you dealing with, if any, technical issues that pop up during your deposition?
Again, it comes down to preparation and pre-thinking and working closely with vendors. Vendors in particular are very good at saying, this might happen, this might happen, this might happen, and here are your contingencies for any of these things pop up. So you just want to be ready for any of those. If it's something completely surprising, then you have your completely surprising catch-all response plan, which can be as simple as, all right, if something completely surprising pops up, then we go on, I will put the kibosh on testimony, we will go mute, we will separate, I will call you, something like that. But it really does come down to having plans ready ahead of time, to include a plan for something you can't plan for.
And then same to you, Matt, kind of with that hybrid approach of being in the office during remote depositions. What are you doing to do any avoidance of technical issues or dealings with them?
Well, I think it depends on the witness. I had a treating doctor who was being deposed in his office, and I think depending on the age and experience of the clinician, you can find varying degrees of technological savvy, and he had very little. The key there was we had an office manager. The office manager was extremely knowledgeable with technology, and she was able to be there, and a couple things came up, and I was able to call her, and we were able to navigate, and we gave her some modest amount, and we essentially retained her for purposes of making certain that things went smoothly, and it was money well spent. So it depends a lot on the witnesses, but you're going to find clinicians who are treaters who are going to represent some unique challenges, particularly with exhibits. And it's always good to find somebody, an ally in that office, who can help you with those moments.
You bring up an interesting point there by having somebody specifically on the line to assist with technical difficulties. Now, speaking from U.S. legal's perspective, we provide somebody we identify as a remote deposition technician who is there as a tech expert, exhibit introduction expert. They are there to try to mitigate some of those problems as they arise. It all goes really back to what Brock was saying. It's the preparation, it's communication with your vendor, it's understanding what outcomes you may face during the deposition and how you will adjust on those moments when it does actually happen. So that really takes us into our next topic, which is challenges that you've faced in the remote world. And I guess this is similar to the last question, Karen. I'm going to start with you. With technology, what are some of the issues that you do face as you're doing preparation, and also as you are in the deposition? What are some of the biggest hurdles you've had to overcome?
Well, I can speak to preparing for the deposition with the witness. As a litigation consultant, that's part of where I put my greatest focus, is getting the witness as comfortable as possible. And the first step is knowing, we're every day in video conferences, it seems, but even experienced expert witnesses may not be using video conferencing as much as we are. So what's routine for us is still novel for the witness. Add to that the fact that if you have a witness who's conversant with one specific branded platform, it might be a totally different platform for the actual deposition, and that creates stress. So, as a few folks have already said, the sandbox experience is get the practice happening in the exact platform, not just one that's analogous, because the witness knows the facts, the witness knows his or her area of expertise, but where witnesses often come across as less comfortable or almost defensive is when they get thrown something that is foreign to them. So it's your job in preparing the witness to make sure it is not foreign anymore. And that way, if there are problems, the other thing to add to it is a backup. In fact, we've sometimes replicated fake problems with technology, etc., where we knew we had a nervous witness to help the witness see how he or she can psychologically and technically get control back in what can often feel like an out of control setting.
Also, I want to loop back to something Matt said earlier. And since the first time you and I spoke, I know there's been a lot of changes and stipulations that you had mentioned earlier. And one of the original things we talked about was when you're trying to schedule a deposition, how have you been dealing with opposing counsel who's unwilling to utilize that technology? It sounds like there's been some changes based on what you've seen by the courts ordering the use of technology that has probably impacted your experience a bit.
Yeah, I don't think anybody's raising objections anymore. We've come a long way in 4 months, and I think I think this technology is here to stay, and I certainly haven't seen any parties objecting to this, and I'm certain that there aren't any courts sustaining those objections. So that was 6 months ago, and those were being sustained, but no more.
Right. And then Brock, I want to ask you a question as well. What has been your experience in the depositions where opposing counsel maybe doesn't have a strong understanding of the technology? Maybe their client is not tech savvy. What have you been doing during those experiences?
Well, so what I've tried to do I have experienced some reluctance on the part of opposing counsel, although I generally agree with Matt that there's far less resistance. Occasionally I get reluctance from opposing counsel to really be as forward thinking as they could be in terms of sharing exhibits or completely using all the capabilities of the platform. What I try to do, and just to provide some context, my practice is typically in the area of government enforcement, white collar criminal defense, civil enforcement by the government, and the government tends to have fewer resources or to be less aware or less tech savvy. I try to make my resources available to them in a good faith way, but also with the understanding that when I provide expertise and resources, I'm able to shape things in a way that's advantageous to my client, my position. And again, to be very clear, I'm talking about approaching this in a good faith way. I would never misrepresent my position or try to mislead opposing counsel, in particular the government in a criminal case, where that can lead to really problematic results. But if I can set up a platform in a way that helps me while making clear what I'm doing to the government, then I'm going to do it. And by owning the sandbox, by owning the context that the testimony is going to take place in, I can shape outcomes.
It's an interesting point. You mentioned just also making sure that you're doing everything you can to ensure opposing counsel has the tools they need. I always suggest refer them to your vendor, regardless who you're working with. 90% of the vendors that I encounter are willing to work with your opposing counsel, because if opposing counsel has issues on the remote platform, that is going to degrade the entire experience for the entire group. It's not going to just be them that is impacted. So I think it's really important to have that open communication channel with your opposing counsel there.
And just to echo that, you're exactly right. I can think of, again, dealing with the government, making sure they understood, adding to my credibility, and also because of the practical improvement in the result, making my vendor available precisely so that everything works and they understand that I'm trying to approach this in a good faith way.
I think you should just kind of take away, put as much on the vendor as you can. They're going to be able to help in a way that your office won't be having the bandwidth or maybe even willingness to expand and help with. The vendors are there for that purpose. Make sure you're using them to the full capacity that you can. Now, to that exact same point, Karen, I want to come back to you again one more time, just kind of preparing for the witnesses. How are you dealing with a witness? I know you've got your kit, you've got all these preparation steps you can take. What about just the simple fact that they don't understand technology? What are you doing there?
Well, part of it is helping them feel like it still is an in-person experience within their own body, even though they're coming across not from somebody in the same room, but across the screen. And so a lot of what we spend time on is helping them get as comfortable and conversational as possible. But sometimes that means coming back at it through talking to them about their demeanor. And there are definitely differences in how someone comes across when they're on video versus when they're on in person, because of the flattening effect that others have mentioned. So it feels counterintuitive to many, but a slightly faster rate on the part of a witness has actually been found to be more credible. The key is making sure that the witness also pauses, because I'm not talking about rapid fire, but I am telling you that a witness who goes too slowly or has been told to pause after every single question all of a sudden becomes more robotic in how they come across. Any of us in typical conversation have a slightly faster rate, but again, as I said, it has to include pausing in between a sentence or two or a phrase or two. All right, so then the next one is knowing that if a witness has a lot of vocal fillers, and nowadays the vocal fillers are no longer just and that it can be distracting. In fact, nowadays a lot of witnesses say like, or so, or kinda, or right at the end of almost every single answer. We've all seen it when we've read deposition transcripts, because a lot of witnesses start almost every answer with the word so, as if they're mid-sentence. Believe it or not, when someone has, again, that slightly faster rate, it helps eliminate some of those vocalized pauses. But other things to consider would also include a witness who is nervous is someone who often will do what I call in the extreme a personality drop. Or if they're concentrating really hard, they get soft-spoken, they get quieter, they sound less energetic, and therefore they don't mean it, but they sound less confident. A number one way to cheat in coming across more energetic, especially because video does flatten out personality and dynamism, is to have a stronger volume. But one thing I've had to embolden some witnesses in our prep with is this. Some witnesses who are more soft-spoken may actually in their own room feel like they're yelling to some degree. In fact, I do right now. This is not my typical volume, but I know that I need to exaggerate it some, both to appear more confident and also knowing that literally your persona can be muted across the screen. And we have, also knowing that certain witnesses, because your voice is so much more front and center, so to speak, when you're in this box of a video deposition as opposed to being three-dimensional in a conference room, people take more in terms of interpretation of what a person's voice is doing. And that includes when someone might have a good opinion, but as they're speaking, their voice tends to go up, like mine is right now. Not only is it annoying, but I don't sound very confident. When all I need to do is just simply have my voice go down at the end of the phrase, like I'm demonstrating right now, I sound more confident even though my words haven't changed very much. And then some other areas for demeanor include just speaking at the lowest natural pitch. We actually speak through 3 cavities. We have options for that in terms of where we're speaking. So the witness who speaks more through his or her sternum is one who is seen, fair or unfair, as more credible. And we just have a few more here. A witness also needs to show that they are engaged in what's going on. So if I'm leaning away or I'm not really centered on the screen and I look either like I have attitude or I'm just done with everything, that doesn't help the witness's credibility. So more of a forward lean is useful. And then natural gestures. This one is fairly comical because this has changed and we've all learned probably by accident that no longer should you motion this way because these are called monster hands when people might normally be trying to make gesture, but now your hands become larger than the rest of you. Yes, exactly, Matt. So the key is if a witness speaks with his or her hands, the last thing I want to tell a witness to do is to stop because that's part of where adrenaline, that nervous energy, burns off. And then the witness feels more calm. So adrenaline burns through strong volume, but also still gesturing, or if there are 2 things they want to say, I'm off screen, there I am, that I need to gesture closer to my body and higher up, which feels like you feel a bit like a dictator in some foreign country, but you do tend to show, again, that you are using illustrative gestures. Also keeping hands away from hair and face. Men sometimes with beards will, I don't know, John, if you've ever done that before, but the key is not to do that because, again, we're now gesturing and noticing this much of a witness as opposed to the entirety of the witness at a conference table. We may have one last one. Yes, eye contact. Again, bearing in mind the important admonition to try to make meaningful eye contact with that dot, that camera lens. And that is so much easier said than done, as we've all experienced. But the key is to know that your facial expressive may feel a little over the top when sitting in the privacy of your own office, but it does come across as more engaged, again, because of the flattening effect that occurs from the person's being to the screen across, especially if it's, of course, being video recorded and may well show up in the courtroom at some point if the case makes it to trial. So the key is for the person to be alert to the fact that their face has a job to do, and that is to be more animated, engaged, and making good eye contact.
Those are great points. Thank you, Karen. And I know we're fast approaching the end of our allotted time slot here, so I just have a couple more questions that really fall under the other category, just things that are worth noting, but just talking about. And the first thing I'll say is just starting with you, John. Looking back now, what do you wish you knew about remote depositions 3, 4, 5 months ago?
Well, I guess I would say what I wish I knew is that they worked. I wish I had known that they worked this well a year ago or 2 years ago, to be honest. That we've all spent so many of our days in airports and everything else. And sometimes it is critically important to sit across from a witness and get a feel for them. And you do lose that in a virtual environment. But there are an awful lot of depositions that we take where the time and money saved in the virtual world is well worth it. So I guess that's my number one takeaway is I wish I knew how well they could work. So that would be it for me.
It's funny you mentioned one thing there that you lose a little bit about the experience with your witness. I've also heard a lot of individuals post deposition mention that they feel they're getting a truer version of the individual they depose because they're not preparing themselves to go into an office, a law firm or a vendor themselves. So they're at their home, they're in their environment, they might get a better understanding of exactly who they're talking to. So there's a little bit of a flip side on that as well, which is interesting. Now, speaking of some of the things that have come up, Karen, do you think any of the new processes that have developed due to the pandemic are going to stick long term?
I do. I do think, just like John said, that it's possible more video depositions will occur. But the thing that's interesting is I'm also part of a community of social scientists, retired judges, and attorneys who are looking at online trials. And certainly hearings have been happening for the entirety of the pandemic. But the idea of the online jury trial is taking longer to take hold. But seeing now it with my own eyes, portions of a witness video that get played within an online trial. Certainly jury trials are happening, especially in the states of Texas, California, Arizona, both in the criminal and in the civil arena. And jurors are actually reporting, and this is why I think it could stick, that they are able to better see the witness instead of those prior jurors who were in a big courtroom, couldn't really have a good angle seeing the witness. Now they're seeing the rerun of the witness in the deposition, and possibly then the witness, him or herself, live. And that is again happening in the comfort of that juror's home, and they're also seeing the witness closer up. So those who have taken the step to online jury trials, we may be in this pandemic for a while longer, tend to be emboldened and looking at doing it more, not less, and incorporating the witness video and deposition versus the witness live.
Actually, U.S. Legal Support hosted the first virtual federal trial in the U.S. District Court of the Eastern District of Virginia. So that really does seem it could become a long-term option. Obviously, we're all hoping that a vaccine is fast approaching and we can resume some in-person activities. I know our time is about to end, so I just have one more question that I want to pose to the entire group. I'm going to ask you all individually if that's okay. Matt, I'm going to start with you. With 2021 fast approaching and the need for remote services appearing to be on the rise, is there any just last-minute advice that you would give to somebody who is yet to participate in a remote environment of any type now in the pandemic thus far?
I don't have advice per se, but I do have a headline I want to share with you. Didn't get a lot of attraction, but Amazon said the coronavirus pandemic saved it $1 billion in travel costs. When the general counsels around the country see what they saved on travel costs for their outside counsel, you're going to see even a stronger momentum push to this technology in 2021 and forward. So that's my parting observation as this technology continues to become more popular.
John?
I would just say embrace it. It can be useful and good. So embrace it. That would be my advice.
How about you, Karen?
In a companion way to what John just said, I would say change your mind. If you are a naysayer and you think it's not possible, change your mind. It is possible. And we keep finding those who are the pundits saying, won't work, can't do it, are the ones who haven't tried it. The ones who are trying it are succeeding at doing it.
And lastly, Barack.
Effective advocacy is about finding asymmetrical advantages in whatever you're doing. So we should be embracing this platform, figuring it out, and being thoughtful, strategically thoughtful about how we can make it work for us and our clients.
Those are all great points. And I know we didn't have a chance to get to any questions that were submitted. I apologize. Obviously, we ran out of time here. Please feel free to reach out to any of your vendors that you work with to get your questions answered. But I want to take a moment to just say, once again, thank you to all of our panelists today. We truly appreciate your time and your insight in this industry. Without people like you, a lot of attorneys out there would be a little bit lost approaching this on their own. So again, thank you so much for your time and commitment to helping the community out and better their knowledge base. To everybody else, thank you for taking the time to watch this. Hopefully you gained some knowledge, and we're looking forward to helping you into the future with your remote solutions. Thank you very much and take care.